Nissan Motor versus Team Imports, Tesla versus Louisiana Dealers, CDK Global $100 million settlement, Texas judge blocks FTC non-compete, and in the matter of Asbury Automotive Group. What's it all about, and how can the average person make sense of legal jargon? Tom Kline, compliance and risk consultant, and Michael Semanie, attorney at law, are here to help. Disclaimer, not legal advice. Please say hello in the live chat, make new friends, and learn from the best on ATI Auto Business. What's up, ecosystem? Welcome back to ATI Auto Business, automotive ecosystem, where everyone learns more about the automotive industry. Let's get started with some top industry news and headlines that include Texas judge blocks no non-compete, CDK to pay $100 million antitrust settlement, Asbury Auto Group payment packing allegedly. At the quarter hour, we got Tom Kline of Vantage Point. He is our featured guest. We're excited to have him here tonight. He's written a book. Michael Semanie, attorney at law, is our special guest in our panel as we are about to get legal up in here. Please do jump in the live chat, say hello, ask a question, share your thoughts, grow your business. Hello, YouTube. Hello, LinkedIn. Please do leave a like and share. You can copy, you can grab that YouTube link. If you've got a legal opinion, a question, or you just want to sit back and kick back and enjoy the legal talk, this is going to be a meaty hour, so let's give it a shot and see what we can do. It is show 361 in a row on a Tuesday. Dealership Lawsuit 101. You've been served. Tom Kline is my feature guest tonight of Vantage Point. You might know Tom Kline. After tonight, you're going to want to talk to him. He knows how to tuck the octopus. He's going to explain what that means. All the tentacles flopping out all the time, and you got to tuck that, man. Stay legal. Stay compliant. He wrote a book. There it is, man. Good job, Tom. That is cool. Wow. So jello, you know? Michael Semanie, attorney at law, is here with us. We're excited to have you, Michael. We are talking about lawsuits. Now, this is civil action, not criminal. There's plenty of civil to do. What's a complaint? Do you know the parts of a face page, right? And what are you looking at? Plaintiff, defendant, court. And then where are you in this action? Has it just started? Are you in the middle? Is it the punishment phase? Are we in summary judgment? What's a temporary injunction? What's a preliminary statement? A hearing? A protective order? Who are all these people? And how do you read a docket? And what is all that stuff? Man, that's just 1 week. So what are we doing? We're going to talk about it. Remember, today's presentation is for informational purposes only, should not be considered legal advice. ATI is where everyone learns more about the automotive industry. Got a legal situation you're curious about? Share it. Again, not legal advice, but we want you to know your ecosystem. You know what's exciting about tonight? Rarely do we hit the compliance piece, but we're going to smash right into it. Tuesday is the automotive ecosystem. It's Tuesday nights. Last week we went live at noon with Central Dispatch. I want to again thank the Cox Automotive Group. That was a great show. And on Thursdays, Logistics Community, that's at noon. And last week we had Aaron of ClearPath TMS on the show. We're kicking off a ClearPath TMS series here on ATI, so you're going to learn more about why OEMs love ClearPath. And this Thursday, we're going to talk about self-dispatch load boards. Now, actually, it's the bulk of the load boards that we talk about. And why is it such a big deal, right? Why? It's a big deal. All right, let's do some news. Here we go. Oh, man. All right, here comes my legal voiceover audition. Here we go. Justice Department sues California Towing Company for auctioning a service member's vehicle in violation of federal law. What? The Justice Department filed a lawsuit against Tony's Auto Center, alleging it illegally auctioned off a deployed U.S. Navy lieutenant's car in violation of the Service Members Civil Relief Act. The SCRA prohibits a towing company from auctioning off a vehicle owned by a service member unless it first obtains an order from a court allowing it to do so. Did you know that? Oh, the lawsuit alleges that Tony's illegally auctioned the Mazda 6 while the lieutenant was deployed aboard off at sea, and the lieutenant had placed some personal belongings in the car, which was parked in front of a friend's house. While the lieutenant was at sea, Chula Vista Police Department impounded the car due to an expired registration. Tony's Auto Center towed the car. 2 months later, Tony's Auto Center, through its agent, sold the lieutenant's car at auction without obtaining a court order authorizing the sale. Oh my gosh. Let's see. Lieutenant returned home from deployment, found his car had been towed, contacted Tony's, learned they sold the car even though he no longer had the car. He had to continue making his monthly car loan payments to Navy Federal Credit Union, which total over $2,500. Wow. Okay, so there's your damages. And Tony's is like, but the police. Wow. And here it is. Oh my gosh, this is crazy. So Merrick Garland is listed at the top of this giant complaint. United States of America versus Tony's. Are you kidding? Does that come by mail? They serve that in person? Texas judge blocks FTC non-compete rule. There will be some unhappy folks, and there will be some happy folks. The U.S. District Court for the Northern District of Texas blocked the FTC's final rule prohibiting non-compete agreements with workers in an August 20 rule. Remember, the FTC prohibited non-compete agreements, and this court is saying, no, you can do non-compete agreements. Judge Ada Brown decision will prevent the rule from going into effect. The lead plaintiff in the case, Ryan LLC, which will be quoted in many a room, a tax plaintiff in the case, celebrated the decision. Today we prevail in protecting the very foundation of innovation that drives our economy from the overreach of the FTC and its misguided mission to invalidate millions of employee contracts. Now check this out. Think about this. This is siding with business, not people. Non-competes serve as a cornerstone of mutual trust between employer and employee. Not true. An argument or a non-argument. As a champion for our clients and business owners nationwide, yes, this is for businesses. Ryan stands proud in the role we played to protect businesses' intellectual property. That's correct. This is a business ruling, not an employee ruling. Anyways, just my interpretation. I'll be here all night. Federal Appeals Court revives Tesla's legal battle against Louisiana's ban on direct vehicle sales. Check this out. Marking a significant deployment in the electric car company's ongoing battle to defend its sales model. So here's a flip-flop. This is a rule against a business's sales model. So where's the equilibrium? Tesla initiated the lawsuit in August 2022 targeting members of the Louisiana Motor Vehicle Commission, dealerships owned by the individual commissioners, and Louisiana Auto Dealers Association. Company Tesla alleged that these entities exploited their control over the Motor Vehicle Commission to drive Tesla out of the market by targeting its direct sales model. Can't have that direct sales model. Can't have it. Which bypasses their traditional network of franchise dealers. Can't go around these dealers. It's the way the granddaddies did it. Tesla also accused Louisiana officials of illegally banning direct sales since 2017 and restricting the leasing and servicing of its vehicles within the state. Can't even service it? Circuit Judge Jerry Smith stated that Tesla had sufficiently alleged plausible actual bias. They have plausible actual bias on the part of the defendants, citing emails. Oh, always check the emails and the Facebook. Let's see. Case now returns to U.S. District Judge Sarah Vance in New Orleans, who had previously dismissed it. Oh, great. Wow. Repeal of Inflation Reduction Act's EV manufacturing incentives, a scary thought. Industry executives say companies allocate around $223 billion to EV-related facilities and initiatives in the U.S. Oh my gosh. We have any good news? The Inflation Reduction Act, now 2 years old, has proven itself a landmark piece of legislation for the auto industry, spurring billions in investments in electric vehicle assembly, battery manufacturing, and parts making. As the November 5th presidential election looms ahead of a new administration taking office in January, the industry is urging lawmakers to preserve the IRA. You imagine what would happen if this thing gets overturned by... That's right. Trump told Reuters that if he was elected, he'll consider ending the $7,500 tax credit for EV purchases. You know what'll do? What that'll do, Your Honor? Oh my gosh. It's really scary to these guys. It's not scary to me, I'm just reading it. 10 companies have committed investments of at least $10 billion in U.S. electric vehicle and battery manufacturing to date. Ford, $61 billion. GM, $58 billion. Rivian, $37 billion. Which is why Ford cancels 3-row EVs, delays next-gen electric pickup, and a $1.9 billion strategy shift, which is a drop in the bucket. That's as far as the headline goes. It's just interesting. Here, let's do this one. Property insurance. Dealers hurdle over EVs. Zurich Insurance Group issues recommended best practices for dealerships servicing EVs that could add costs. You don't want to see that. Legacy automakers have spent years trying to figure out strategies for EVs. Now another. Property and casualty insurance. Results may eventually force dramatic changes in the way dealerships manage their costs and transitions to hybrids and EVs. Wait for it. Boom! Isolated stalls for technicians to work on EVs. Isolated stalls. Immediate return of defective, damage, or spent EVs to the manufacturer. Physically isolated battery storage. Extra caution in areas prone to flooding. Oh my God. I didn't even go to the page where it talks about fire. CDK Global is going to pay a $100 million settlement in a landmark antitrust lawsuit, and it's benefiting dealers. This isn't even recent. CDK Global set to pay $100 million to settle a class action antitrust lawsuit. The lawsuit was filed in 2017, originally against CDK and Reynolds. However, Reynolds previously settled, which is always great when your co-defendant settles. You can guess what you'll be doing. Key takeaways. The class action suit has accused major DMS providers of colluding to overcharge dealers by charging a high fees for access to their own data, which third-party vendors aggregated. The settlement will benefit approximately 1,200 to 1,700 dealer rooftops, covering from 2013 to now. Okay, 11 years. This settlement indirectly fosters a more competitive marketplace. For a little bit. The lawsuit has led to increased competition in the DMS market with new vendors entering the space. This case sets precedent for how class action suits can address systemic issues within the automotive industry. Wow, this is going to be quoted a lot too. And the FTC, Asbury Automotive Group, Inc. et al. In the matter of... What is this one about? The FTC is acting against a large auto group, Asbury Automotive, for systematically charging consumers, allegedly, for costly add-on items they did not agree to or were falsely told were required as part of their purchase. The FTC also alleges that Asbury discriminates against Black and Latino customers. You do not want to see that. Targeting them with unwanted and higher-priced add-ons. Yikes. In an administrative complaint, the FTC alleges that 3 Texas dealerships owned by Asbury engaged in a variety of practices to sneak hidden fees for unwanted add-ons past customers. These tactics included a practice called payment packing, where the dealership convinced consumers to agree to monthly payments that were larger than needed to pay for the agreed upon price of the car, and then packed add-on items to the sales contract to make up the difference. And Rhode Island dealer settles deceptive sales claims for $1 million. Coulter Motor Co. settles vehicle pricing add-ons. Yeah, so there's no, it's just them. Speaking of tonight, dealerships lawsuits 101. Good topic. I've been through myself. 5 lawsuits in the past. First was a dandy customer fraudulently filled out credit application and lender caught them. A car chase was invoked by a foot chase. A 2-year legal battle, breach of contract. Wow. This stuff's crazy. And we didn't even get into Nissan Motor versus Team Imports. This is a complaint dated August 2024. I believe Tom is going to help guide us through this conversation a bit. We're the neutral zone. I was thinking this, before the break, is that, what I'm doing, right? What is going on, Jay? Right? There can't be that many people that want to, dive into this show and, do this. Right? But you know what? When I watch content, I want the best. I want it thorough. I want to know as much as I can. And I say this and I know this because when I see videos over and over, and it's the same little, it drives me crazy. So we're not doing that. We're not doing pets and little sound effects and whatever. No, we're not doing that. We're going to jump into this legal show. It's going to get crazy up in here. Stick around. Do me a favor. We'll be right back with Tom Kline, consultant and risk expert. Stick around. We'll be right back.
Transport Auto Quoter is by far the leading auto quoting software on the market and the only auto quoter with a pro version that comes preset with accurate pricing for anywhere in the U.S. So you don't have to worry about it. The best part is that no change with your current software is needed. Just plug TAQ in and start booking jobs. Carriers can easily plug TAQ into their current websites and start making money right away. I bet you're wondering how we do this instantly and accurately 24/7. Well, constant analytics is the key. Our Price Watch team is constantly monitoring current market conditions, paying close attention to seasonal and quick-moving industry changes. At the end of the day, it takes a lot of time and data to maintain good pricing, time that most of us just don't have on a daily basis. So free yourself up. Using TAQ Pro is really a no-brainer. Save time and money, maximizing your leads and optimizing your online investments. You'll finally be able to sleep well at night knowing that TAQ is on the job selling for you 24/7. Never missing a potential job.
All right, we need to brainstorm for this commercial. How do we show our audience that we're the best auto transport platform in the industry?
Oh, we need to show them our dispatch manager. Optimizing routes has never been easier.
We should definitely show them our EDI management screen. Managing contracts is simple with ClearPath's EDI toolkit. Who doesn't want to work with the big manufacturers?
These are all great ideas, but we need to highlight what makes us special.
Sure, we can talk about all our awesome features, but the bottom line is we invest in every single one of our clients, giving them the power to scale up and increase their revenue.
That's perfect.
Automakers love ClearPath TMS for its robust EDI integration, customized APIs, and full auto transport business platform. Request your demo now. Visit clearpathtms.com. All right, got a link in the live chat. And again, like I said, I know that... oh, thanks, Mark. Thank you so much. And Moosey's here. What's going on? 925. So, we're going to try this. We're going to do some legal stuff. And I know Tom is excited. So here we go. There comes a drum roll. Okay, Tom. Here we go. Tom, can you see me and hear me okay?
I can see you and hear you live from my Marriott hotel room.
Ah, you're in the hotel. Gotcha. As we know, when we are out of the studio, it changes things, right? You had another camera, and what was the other camera you were trying to use? Was
Well,
it a
I have backup cameras, right? Because I'm on the road, so I have a built-in camera, a backup camera. Want to make sure you can see me.
do me a favor. Now I'm going to try this. Switch to the other camera for a second, because I think the audio on this one, like I can hear the kind of the compressor on the audio is going to be it's going to be working us a little bit. That's okay. This, while he's doing that, somebody asked me hey, we could do a live show on the road. I'm like, man, that is actually a lot more work. I'd rather be in the studio. So hats off. Hey, anybody doing a show on location? I will say this, Jason Harris, that guy does a lot of on-location shows, and his video looks good, his audio looks good, so shout out to Jason Harris. All right.
Good.
See me, hear me? Check, check. I know, right? It's a good thing this isn't a technical show. It's a legal show. Let's give it a shot. Let's go legal. You ready? Okay, now I can't hear you. But I did that. I'm the one that said, let's try the other one. Now we've got...
How about
yeah, I hear you now. All right, here, we're good. All right. So, all right, Tom, welcome to the show. Welcome back.
Thank you. Great to be here, of course.
Thanks for agreeing to do a show while on the road. I know that, being out of the elements and stuff. But, hey, let's go into Attorneyville. Attorneys travel all the time.
Right.
How often is an attorney actually at home?
Well, if they're lucky, they get to practice where they live. Some do, some don't, right? Depends on where their clients are. And it depends on what kind of law they practice, right? The trial attorneys go where the trials are. As James Bond said in one of those movies, he said, he has a Russian, I go where the work takes me, right? So that's kind of how lawyers are. Right? Tax lawyers, they get to sleep in their bed every night. Just depends on what kind of law you practice.
That's fair. That's fair. All right. Now, you're not a lawyer. We're talking about lawyers. We're going to be talking about law and legal stuff. You're not a lawyer. You're a consultant.
Correct.
In a nutshell, tell us what is Better Vantage Point and what is Tucking the Octopus?
Right. So for everybody, thanks for listening tonight. My name again is Tom Kline. I was a dealer for 30 years. And so I lived in the dealership world, and I'm now consulting with dealers. My family's actually been in the car business for over next year will be 100 years. We started in 1925, so I'm a third generation car guy. And I say that running a dealership is like trying to tuck an octopus into bed, but the tentacles keep flopping all over the place. And my job as a risk consultant, so I'm a risk and compliance consultant, is to help you tuck the tentacles in and protect your business, safeguard your assets, make sure you have enough insurance, make sure you have the right coverages, make sure you're complying with the laws and the rules and the regulations, which are ever changing. And that's very complicated because, Jay, over my 34, 35 years now, I actually compiled a book that's 48 pages long that just lists all the rules and regulations. That's all it is. So there's an incredible number of things that car dealers have to deal with, and they're more heavily regulated, in my opinion, than banks or stockbrokers or real estate or any of that. So my job is to help them make the right decisions, both from a risk and a compliance perspective.
On the legal part, so what I did was, with the news, I went extreme legal. Did you see the news? Were you able to see that?
Yes.
I mean, and that first article I read was the most off topic for dealers, where the United States is suing Tony's Auto Center for selling a vehicle that belonged to a service member without informing the court beforehand. How in the world would anybody know that that's a thing?
Yeah, so the Soldiers Sailors Relief Act, I think is what you're referring to.
Yes.
That it's, the law is there to make sure that while our service members are serving their country, that they're not taken advantage of. And it came about, I'm sure, because there were a lot of bad actors who were taking advantage of sailors and Army folks and Marines while they were serving our country. And so there's a certain process you have to go through before you can repossess a vehicle from an active duty service member. And it's a very complicated law, but in short, that's what it says.
Now, I mean, so I'm guessing, did you know about this?
I was aware before the case, yes, because I grew up and lived in Virginia Beach and Norfolk, Virginia, which is one of the largest military installations in the world. So there are additional regulators like the Armed Forces Disciplinary Control Board and others that routinely go and have conversations with car dealers depending on how they're doing what they're doing.
Okay. All right. But Tony's sold the vehicle. It was the police department that told Tony's go pick that up?
I think so. I don't remember Tony's specifically, but I think that's correct. There have been so many lawsuits and articles recently. It's hard. I made a spreadsheet the other day just so I could try to keep up with them because there have been so many regulatory actions by the attorneys general and the FTC and the CFPB. It's really hard to keep track of all of them.
And here I am. Isn't it your testimony that Tony was not planning on? Okay, so, all right. Let's get up.
Isn't it true is the question.
Isn't it true? Right, isn't it true? So, all right. Yeah, like, once you realize there's an octopus to tuck, and you start to look at, these are just recent headlines.
Right.
This gets wacky.
Right.
Of course, you can't use that term, but I suppose, is that why the octopus seems really, how did you do that? How did you get to octopus?
I was after having been in the business so long, I was trying to figure out a good way to describe what I do, right, in a very graphic way. And the things I talk about with dealers vary so much, but it's all risk related. I mean, I was at a client today, and we were talking about healthcare and some of the rules and regulations and how he can save money and how he can enhance his benefits. And then we had a conversation about a software program that he just signed up for that will help him tuck the octopus. It's an organizational software, that automates a lot of the rote activities so that his staff can do less pestering of people, right? The controller calling up and saying, why haven't you gotten this to me? When you can automate those kinds of functions. It's kind of the one throat, I call it the one throat to choke program, which is all your information is housed in one place. And when you think about compliance, Jay, compliance is a word that nobody likes, right? Because, if your significant other said, I want dinner at 6 o'clock, Jay, you better comply, you'd be like, what did you just say, right? And so as human beings, we don't love the word compliance. Nobody likes to comply. So you have to think about compliance in a kind of a different way. And the paradigm that I like to share is that all compliance is someone has to do a thing, whatever that thing is, at some point in time, and then prove that it was done, right? That's compliance. Someone has to do a thing at some point in time and then prove it was done. And when you think about it that way, going to the Monday morning meeting is about compliance, right? The salesman has to go to the Monday morning meeting. They don't have a choice. And so when you start thinking of it in that terms, there's a lot of things that are tied up in compliance. And tucking the octopus is just doing that, is creating a way for you to be able to get done what you need to in the most efficient way possible.
I'm so glad I asked you that because that was really spot on. So here we go. Before we bring in Michael, I called you, I started talking to you, and you start telling me about this thing. Nissan versus Team Imports.
Right.
Now, I didn't really dive into this because I don't know what this case is about. I just know there's several things to look at. I'll pull up the complaint. Tom, what is going on here?
Yep. So this particular dealership was what in the car business we call is out of trust. And what out of trust means is car dealers have what's called a floor plan. So they don't necessarily, some do, but they don't necessarily own all their cars for cash, right? They have a loan for each particular vehicle. And so when they sell a vehicle, they are supposed to pay the bank off and they keep the difference between those two, right? So if you have a car that's floor planned, let's say it's a new car and it's floor planned for $30,000, that's how much you own it for, just for sake of an argument, and you sell it for $35,000, the dealership makes $5,000. You then take the cash when you get it, you pay off the bank, and you go on about your business. In this particular case, this dealership didn't pay off its floor plan to the tune of $2.6 million. And so Nissan sued the dealership to protect their inventory because they have a lien on all the inventory. So they put what's called an injunction, which is asking the judge to stop their ability to sell any cars until they're caught up on their floor plan. Essentially, that's what it says.
Right, and as we were talking about in basics, okay, an injunction is an order to stop doing something?
Correct.
Okay. What's a protective order?
A protective order is where, let's say, as a part of a case that, let's say a car dealer is getting sued, and part of the case that the plaintiff lawyers want to put on is they can afford to pay this poor person, however much money they're asking for. And so they want to get financial information from the dealership. Well, the dealership doesn't want to give up financial information, and they certainly wouldn't want that financial information out in the public eye. So the dealership would ask in this circumstance that there would be a protective order issued so that only the specific parties that are related to the litigation can see those financials. So it's literally it's protecting a piece of information that maybe if it was the government, maybe it's top secret. In a car dealer's case, most of the time you're talking about the financial information and the financial health of the dealership.
So a protective order is what marks it as confidential?
Yes, the judge has to grant.
Fascinating.
The judge has to grant and say, yes, this, you have to have an argument about that because you're in court. And so the plaintiff attorneys may not agree that that's, worthy of a protective order. So as the dealership's lawyer, the lawyer would have to go in and say, we want this information protected. It's not the public's business to see our financial information. So we want it protected.
Right. And then the judge rules on whether or not it's protected. That there is a protective order, and then if they don't like the ruling, then they cite case law.
That's all part of the argument that the lawyers make.
That's crazy.
And so and there's a right of appeal, not repeal. There's a right of appeal if it's called an interlocutory appeal, where it's very rare, it's not done very much, but you can, in the middle of the litigation, stop the litigation, appeal that one issue. Assume the dealership gets, ruled against, and when Michael Semanie comes on, he can talk more about interlocutory appeals. But because remember, I'm just a business guy, I'm not the lawyer.
Right, the lawyer's in the Zoom waiting room. What are you guys doing? Talking law. Let's do this. Here, do us a favor. We're gonna welcome attorney at law Michael Semanie is now joining us live. Oh, you know what, Jay? You can't just announce him. He doesn't appear out of thin air. You have to let him into the room. All right, here we go. Please do help us wish a warm welcome to Michael Semanie, attorney at law. And Tom, thanks for bringing Michael along tonight. We really do appreciate it. Michael's been very patient. Michael, when you're able to turn on your mic and your camera, we're ready to see you and hear you. Michael, can you see us and hear us okay?
I can hear you, Jay.
Great. We can see you. We can hear you. Please say hello and tell us a little bit more about you.
Yeah, hey everyone. My name is Mike Semanie. I'm an attorney. Licensed to practice in Florida, New York, New Jersey, and DC. We have my firm has offices in Florida, New York, and New Jersey, and I've been representing dealers for about the last 15 years, almost exclusively. So we do, in addition to doing dealership buy sells, so we'll do some M&A activity. We're buying and selling dealerships. We do a lot of litigation for dealers, and that can be anything from disputes with the manufacturers themselves to disputes with banks and lenders, disputes with consumers, disputes with employees. This is the automotive industry is definitely it can be a litigious one. So they keep us busy with that.
We call
Um,
it
eh,
dynamic, Michael.
what's that?
We call it dynamic.
Exactly. Dynamic is a great way to put it. Absolutely. It really is kind of a function of so many different laws, bodies of law applying to dealerships. Tom was talking about some of the lending practices and things like that before. A lot of dealerships are subject to the same regulations banks are subject to because they're originating these. I don't call them loans, but it's financing for the vehicles. So they're subject to not just the regular. You go to the corner store and there's a mom and pop store that's subject to some consumer protection laws. Dealerships are subject to a whole lot of specific laws, both for the financial industry, some that are specifically for dealers. Here in Florida, we have the regular Consumer Protection Act, but then we have a whole section of it that's dedicated only to dealers. So it's a unique industry. It's one that is very impactful. It's important for our economy and for the country. And because of that, it does get a lot of scrutiny.
Man, I'm trying to keep up, trying to wrap my head around. This is a lot of stuff.
It is.
All right, you got retail finance, consumers, insurance. We all just think of the regular fender bender as the main thing that can happen, but that clearly isn't the case.
No, it's not. It's funny in this practice you get to know a lot of different types of law. For example, and things that you probably wouldn't even think of necessarily, but you have someone in for a service. Most of the franchise dealerships have a service division that you bring your vehicle in, you get oil changed, you get whatever replacement parts you need to have done, and sometimes they'll put you in a loaner vehicle or a rental vehicle. And what happens if the customer gets in a wreck in that loaner vehicle? A lot of states have laws that would then imply liability to the owner of that vehicle, which would be the dealership. Well, we have a federal Graves Amendment that can help with limiting that liability for dealers, and then some states also have state law that limit that liability. But things you wouldn't necessarily think of. You think of just, hey, look, I have a service customer in. I'm going to give them a loaner as a courtesy to be able to drive around while I'm working on their vehicle. It's a nice thing to do. They get in an accident, now all of a sudden I'm on the hook for the liability if they hurt somebody under it's called the dangerous instrumentality doctrine. Well, the legislature said, well, that doesn't seem right. That doesn't seem fair. So let's figure out a way to insulate that a little bit. So the legislatures have, the automotive industries has got some great lobbying arms. NADA has done a great job with lobbying to both with trying to make things fair with the FTC, with a lot of other lobbying efforts. And so the industry does have some good laws on the books. It has some onerous ones, but it's it's a bit of a trade-off.
And if I can just chime in there real quick, Jay, but just to follow up on what Michael said, if you have a rental company, and we're not talking about a loaner, just to be clear on what Michael is saying, if you have a rental company and you are renting cars to customers and getting reimbursed for all, for your warrant under the warranty, check the rules and regulations. The reason I say that is I was recently in a Subaru dealership, and most of these policies are written through Empire Fire and Marine. And most of the manufacturers, I think Ford, Mazda, Subaru, Nissan, they all use the same form for their rental companies. And what the policy says is super important, which is before you put that customer in a vehicle, the service department is required to check and verify that the customer has insurance. If they don't take that step to verify the insurance, Jay, then they have no insurance because the insurance policy coming from the manufacturer that they're paying for will not pay for the accident, which means the dealer is then on the hook for the accident. Does that make sense?
Well, it does, and you had me thinking about, there you are, just got off the plane, you're gonna rent a car, you go through that conversation. Do you want to get our additional whatever? And you go, nah, I'm covered, my credit card, my insurance. All right, are you sure? One last chance, and this is your opportunity to make sure you have that correct. I'm assuming the dealer, being nice, giving a loaner, has to have that moment of, are you sure, right? It's an important moment.
They have to verify it. It's not so much they have to pay for extra insurance, but if it's only, and it's only if they have a rental company. The differentiation here is if you have a rental company and you're, quote, renting cars, then it comes under this additional policy that's provided by the manufacturer. If they just give you a car and it's not a rental, then that then comes under your garage liability policy, and you would be covered under that case. It's the rental scenario that kind of throws a wrench into the process, if you will.
Because it's its own form of commerce in that instance.
Yeah,
I suppose
a rental is a different thing than a loaner.
Right.
And I will say there a little caveat to that is before some state laws now change that a little bit. Under the Federal Graves Act, that was we were advising dealer clients when they were doing service loaners to make them service rentals. That end up being part of the benefit of what they're getting, and so we could show that there's some consideration for that deal, and that helped them make the argument that they could fall under the Graves Act, meaning there's no liability for them or their insurer. Some states now, Florida included, have a law that specifically address service loaners. And so we don't have to go through this, all the machinations of being able to say it's a service rental, not a service loaner. In Florida, under some state laws, in addition to Florida, that's covered now under state law as well. So it basically what it does is bar this dangerous instrumentality doctrine to say, hey, you're the owner, so you're responsible.
So, Michael, has the Graves Amendment been tested in court yet since it was passed? Was it 6 or 7 years ago now?
Absolutely. It has, and it's been nuanced different results depending on what district you're in. So it's like a lot of other things. It's, a lot of times what they say is that, the legal answer to so many questions is it depends.
Right.
It kind of depends. But it's also, you have to make sure you're checking your state jurisdiction as well, because that may end up trumping it. You don't have to even worry about it.
And this, Jay, just so you know, for 2 minutes, not to dwell on this too much, but I think it was Chase pulled out of leasing back 10 years ago, 15 years ago, and said, we're no longer going to lease vehicles in the state of New York because there was no amendment. And that's how, and it was that bad that they just said, because I think there was, Michael, you can correct me, I think there was a $200 million judgment against them, against Chase, just for leasing a vehicle. They were just the owner, and there was a $200 million judgment against them. And so subsequently is when the Graves Amendment was passed by Congress, and Chase went back into the leasing business again. So that's a little bit about the history of that.
Well, I was thinking about the NADA when you were talking, and in fact, I believe it was the FTC article where the Texas judge blocks. Mm-hmm. Don't you find that? I know it's not a dealership lawsuit, but isn't that fascinating?
It is. It's and it does apply to a lot of dealers. A lot of dealers have, their look, they have general managers in there that they have access to all of their customer records. They have all this, trade secret information about them, how they do things. It's important for them to not say, hey, look, I'm going to go now compete with you at the dealer down the street and use all of your customer information that I have. So it's important for them to be able to use these non-competes for specific types of jobs, right? It's not going to be maybe for your lot porter, not for your greeter, not appropriate for those. But for the ones that have access to certain information and that are a sort of a higher level, that's very important. So no, that was an important ruling for sure, and it really came on the heels of the Supreme Court recently struck down the Chevron doctrine, and basically what that was that the courts were supposed to give great deference to these administrative agencies, so that hey, if the FTC interprets it this way, they'll let them interpret it that way. We'll go with it.
Chevron gets in here.
Well, Chevron, the fact that Chevron was struck down, now the court looks at this under a different standard. Now they don't go, well, look, I'm giving deference to the FTC. They said they want to do it this way, let them do it this way. Now they're saying, well, let's take a look at this independently. Now I can use my own judgment to see whether I think this is right or not. And basically what the court said was, one, it's overstepping because you're FTC, you're actually promoting or promulgating substantive law, not just procedure. And that's beyond the scope of what Congress gave you authority to do. So that was an issue. And then it had a couple other, actually it was a couple bases for being able to strike it down. So that's why I think it's probably going to be pretty solid on appeal. But it's, that was a very, very important decision. And yeah, it's Chevron doctrine, the fact that had been stricken down played into that decision.
Yeah, that makes sense. Because I wondered where, as a layperson, where is this Chevron doctrine ruling? Where are we going to see effects of that? What you said makes sense to me. At the same time, I mean, I never thought it made sense that the FTC had the authority to have that effect on non-compete clauses, but I think also there were a lot of individual Americans that were looking forward to a loosening of non-compete clauses. And, if I may approach the bench, I don't think that a non-compete is what stops an ex-employee from sharing deep secrets and client files of a previous employer, right?
It's not. I mean so there's a couple caveats to that. There's a lot of states have adopted their own laws now for that control non-competes in their jurisdictions. In addition, that even before any of this FTC was coming out with a non-compete ban, it's a pretty rigorous standard to be able to show that there's an enforceable non-compete. You have to be able to show that it's reasonable in its geography, it's reasonable in its scope, it's reasonable that you have an actual business justification, which that's a pretty high standard to be able to show a business justification for those things. There was a case some time ago where Jimmy John's was saying that their sandwich makers were on non-competes, and the court's like, wait a minute, what is your business justification for that?
We taught them to fold the bread.
It's exactly. And they said, yeah, you can't do that. So there was already a standard there that was pretty high to be able to show that. The ban where it's just outright ban, that was cumbersome. And one of the things that was, I had to kind of consult with some dealers on is that's in the context of your ongoing employees. There is some exception even in that rule as it was drafted before for M&A activity. So if I'm selling my dealership, they might be able to get me on a non-compete because I'm giving them all of this information and I'm giving them my business. I'm selling it to them. They're paying for it. Maybe I shouldn't be competing with them, turn right around and open my dealership right next door to them too. So there are some caveats that went along with that didn't get a lot of publicity, but they are important to note. So going forward, we're still subject to state law on non-competes. So that's really what people need to, dealers and other business owners need to be looking at.
And Jay, just one quick on that to follow on what Michael said. If you have in your employee guidebook a non-compete and every employee signs it at onboarding, you're making a mistake.
For sure.
Even if the one person who actually does have, and Michael will back me up on this, even if the one person who does have information that you would want on a non-compete, the lawyer is going to find out that you have every single employee sign it. So if you have that in your guidebook, get it out of your guidebook because it's not going to be enforceable. Now you can try to trick the employees into thinking that, or you can, there's lots of things you can do, but you take on the risk of the ones who really have the valuable information about making those unenforceable. Michael, you agree with that?
I do agree with that, and it's really not needed. I mean, I've been consulting with dealers about how let's really talk about what it is you're trying to accomplish, and let's figure out a way to do it. Jay, to your point, I mean, if that's not really what we're looking for, I can get you a non-solicitation agreement that says you're not going to solicit my customers. I can get you a non-solicitation agreement that says you're not going to solicit my employees. All these other things that we can do that don't run afoul of the law, that don't really push up against this restrictive covenants to not compete, not make your livelihood in the industry. You don't have to do that. You can just make sure that you're protecting your trade secrets and then your confidential and proprietary information, and that's really what you're trying to accomplish. And there are ways to do that without a non-compete.
Non-solicit, right? Because that's what we're talking about.
Mm-hmm.
That's really interesting. Okay, so cases in the news.
There's been a lot. To Tom's point, there's been a lot of stuff lately. So
This show goes till 11 p.m., right?
yeah,
That's right. Tomorrow. Yeah. Yeah.
We can talk about this, right? I mean, Michael and I can talk for hours about this.
really good.
Let's go.
Yeah,
Let's go.
there's,
Let's go for a bit. Yeah.
Yeah, I mean, it's funny. There's, we've probably seen a lot in the news about the FTC's CARS rule. Even with, and it's funny, it goes back to even just talking about the very nomenclature of the names that we're calling things. The FTC calls it the CARS rule, and the CARS is an acronym under their lingo for combating auto retail scams. Well, automotive industry is like, well, wait a minute. Let's not have scams in the name of what this rule is. That's you're kind of already tipping the scales.
How often do you beat your wife?
Exactly. So NADA has gone back to said, look, let's not call it that. Let's call it the vehicle shopping rule. That's what you guys started with. Let's keep it, fair. Same thing with, they've called things, junk fees and add-ons. NADA has a whole different phrase for it. They call it voluntary protection products because that's really what they're trying to accomplish. To your point that we were talking about with the Service Member Civil Relief Act with the towing and the sale of the vehicle, there was a similar interesting interpretation of the Military Lending Act not so long ago, where some administrative agencies were saying, "Hey, look, you can't sell gap insurance to service members."
That's right.
And there was a big fight about it. It was a new interpretation that the CFPB had put out there. And the auto industry kind of said, well, wait a minute, why? It's an insurance product. If there's a military member that has an accident, the insurance covers the replacement value or the fair market value of the car, but it's not a replacement value. So there's this gap now from what I owe under my existing financing for the vehicle. I'm on the hook for that now, and I can't buy an insurance product for it. How is that helping me?
Yeah.
It was very, the incentives that they were trying to, that they were creating there were just very perverse for what they were trying to accomplish. So the fact that I think, take it with a grain of salt when someone says junk fees, because, what might be junk to the FTC might not be junk to consumers. And so if a consumer wants a dealer, it should be able to sell it to them. It's the area where it gets in trouble is where, like in the case that you saw before about the payment packing, where a dealer says, hey, look, can you afford X amount per month? Well, we know the vehicle, I can sell it to you for a lot less than that. So now I'm just going to throw a bunch of products in there to get that up to that much a month and not tell you about it or make you think that they're required, something along those lines. I got it. That's not fair. That you shouldn't be doing that. But for a willful, where a customer comes in and says, I want this product, should be able to sell it to them.
Even interestingly on the gap that you bring up, because I live in Norfolk, Virginia, home of the largest military installation in the world, I talked to lots of JAGs when I was at the dealership because sailors would get in trouble and they wouldn't know what to do, so they go to the JAGs. All the JAGs liked Gap. I also know a lot of consumer protection lawyers. They like Gap. So it was a very odd time, and unfortunately that's behind us. Yeah. But Jay, to kind of a more broad stroke about what's going on right now, and there's been a lot of cases when you're trying to do when you do bait and switch advertising, you're trying to deceive customers in any way, shape, or form, and that's with products. That's with the price, that's with payments, that's with anything. That's where the attorneys general and the FTC have joined together, and they are joining together more often than ever now. And there's actually a press release within the last, I think it's 6 months, that talks about the new joint cooperation between the attorney general and the FTC. That's where dealers are getting fined right now, is the deceptive acts and practices. And so overall, don't be deceptive, right? If you have an advertised price, sell it at the advertised price. If you are selling products, best practices is, so let's say you're buying Gap. In order to prove, because in fact Asbury as one, is one of the dealer groups right now that's arguing at the FTC. And what they're arguing over is that the customers say they didn't know that they were buying certain products. And so the way you combat that is number one, buying that product when the customer's in the F&I office, that product should be on the buyer's order. So they should sign a final buyer's order with the price of that product. Number two, they should sign a menu accepting that product and accepting the price. And number three, that same price should be on the retail installment sales contract. So, and I forgot number four, there should be an actual enrollment form of that product with the same price on there. So if a customer goes to a regulator or a lawyer and says, I didn't buy this, I didn't know what I was getting myself into, the dealer should be able to pull their deal jacket and say, okay, well, here's the buyer's order where you agreed to it. Here's the retail installment sales contract you agreed to it. Here's the menu where you agreed to it. And here's the enrollment form where you agreed to it. That's how you combat this.
One other point with that too is on the menu, you should also make sure that there's something on there saying that they understand that's an optional products. They're not required to purchase the vehicle. You can purchase the vehicle without it if you want to, but these are optional products that you want to purchase, you can.
Correct. I agree.
So I can see at this point, wait, if you've got several forms for me to sign, aren't I starting to feel like, why are there so many forms where I'm feeling like this is a problem, but actually it's protection against some of this regulation stuff?
It is, and you know, look, that the CARS rule is on hold right now, but if that does go into effect for some reason, you're gonna have a whole lot more forms to sign. You know, it's the FTC's stated goal of making things easier for consumers and more fair for consumers really is going to have this, I think, unintended consequence of making the process of buying a car much more cumbersome, much more difficult, much longer. You know, there's a lot that goes along with buying a vehicle. There's a lot of, you know, it's a major purchase, but it shouldn't be as difficult as it would be if that CARS rule is passed. You know, a lot of the issues in the CARS rule are addressed a little bit elsewhere. You know, the kind of dovetail back into Tom's point, you know, a lot of state laws dictate how you're supposed to disclose pricing in advertising. It doesn't go as far as the CARS rule because some of it just doesn't really make sense the way the way you would have to do it. Pragmatically under that CARS rule, it would be very difficult for dealers, if not impossible in some circumstances, to comply with that. One thing that I think that is important for dealers to recognize too, though, is I hear a lot of times where dealers will say, well, look, I'm a small dealer, you know, it's FTC, it's a federal trade commission. They don't care about me. I've got, you know, 3 stores. I don't matter for that. What Tom was saying about the FTC, you know, kind of cooperating with state attorneys general, that's important, but I'll take it a step further. What I always see is whenever the FTC signals that it's taking some sort of enforcement actions, that trickles down to the attorneys general for different states, but then that trickles down to private plaintiffs' attorneys, because remember, they're bringing the FTC Act, the federal act, doesn't have a private cause of action. The FTC can bring claims, that's it. But each state has this mini FTC Act. Every state has a Consumer Protection Act that we kind of lovingly refer to as the mini FTC Act. Those allow the attorneys general to bring the same types of claims, and they allow private plaintiffs' attorneys to bring the same type of claims. So when even though you may say, hey, look, FTC doesn't care about me, I'm too small for them. If a consumer goes to one of these you know, plaintiffs' attorneys and they say, hey, look, I was told I was going to get 1 extra floor mat and they didn't give it to me, and now I'm mad. Something silly, right? Maybe the plaintiff's attorney says, well, I can't do anything about that, but let me see your deal documents. Let me see what they did. Let me see if I can find anything else. And if they can find something else like that, they already know the FTC's been taking these actions. They know that state attorney general have been taking these actions. Now I know I can bring this action as a private claim, and I really have something here. So it's putting it on the radar of a lot of the plaintiff's attorneys. And there are a lot of plaintiffs' attorneys out there who will you know, they make their living suing dealers. We have a plaintiff's firm here in Florida that the name of the firm is Sue Your Dealer. It's, you know, there's a big industry for suing dealers. So that's where we, you know, I think Tom is doing a great job of keeping dealers protected to make sure that they're not, you know, doing something that's going to put them in the crosshairs of whether it's the FTC, the Attorney General, or a private plaintiff's attorney.
And let's make no mistake about these lawyers, Jay. These lawyers know their way around a deal jacket. And just like Michael or I can pull a deal jacket and find legal problems in almost every one of them, they can too. And so dealers should not get comfortable thinking, oh, well, we're clean and we do everything right. literally we can pull a deal jacket and find something wrong. And that's number one. Number two is I like to say that problems at dealerships come on two legs, right? They're either customers or they're employees. And if you're handling your customer problems and you're handling your employee problems, no matter how wrong the customer is, and I use the words wrong in quotes, because a lot of dealerships have the paradigm of, well, we're not going to fix that because we didn't do anything wrong. We did everything right. And what I'm going to say to the audience tonight is, it doesn't matter whether you're right or wrong. You're in business to make money. And part of making money is you fix the problems with the customers. Because if you don't, and quick shameless plug, in my new book that was just published, Tuck the Octopus, A Better Vantage Point for Dealership Risk and Compliance, I have a chapter called Let the Government Be Your Customer Service Department. And in that chapter, of course, you don't want the government to be your customer service department, but if you're not fixing your customer problems, they are going to step in and they are going to tell you how you need to fix your customer service problems. And they're going to fine you in doing it. So if the dealership is aware and making good choices on handling customer problems, you will not have a problem with a regulator. But if you don't respond to your internet complaints, if you don't respond and have a mechanism somehow in the dealership to capture the feedback before they post on the internet, you're just inviting problems from plaintiff lawyers and from regulators.
What part of the dealership is responsible for handling, seeing these issues before they blow up?
Yeah, it's a great question, Michael. You want to start and I'll finish on that one?
Yeah, absolutely. I mean, from my perspective, it's always when it's something where I have different dealers have different philosophies. I like working particularly with the ones who say, I'm going to empower my employees to be able to resolve certain issues. If it's small issues, just resolve it with the customer. Let's move on. Let's keep going. If it's something that is maybe a little bit more complicated than that, that always should be going to the GM. The general manager should be making decisions on, okay, look, this is a serious issue. I need to either make it right with them, or if I have any kind of inkling that I can't make it right with them, or I'm not going to be able to do it, I need to get with legal now and find out what my options are for how to go forward. Because I can tell you, a lot of times there are options that you may not be thinking of on the ground. The GM may not come to mind because it's not something that they're used to dealing with as far as the legal side of it. But when we talk it through, a lot of times we can come up with an option that's not, just digging our heels in and saying, sue me if you want to sue me. That's not the best option usually. We can find alternatives to be able to say, I'm sorry you had that bad experience. Here's what we're going to do for you to make it right. And it may not be paying money. It may be something else. A lot of times it's not a money issue. It's something else that's going on, and we can figure out what that is together. But to me, that's the best way to do it. Smaller issues, you empower your employees to resolve them. If they're a little bit over that level, having the GM see if they can resolve it, or getting with counsel that they can just get on the phone with right away and say, hey, what do we do about this? Or what are your thoughts? To me, that's key.
Yeah, and just to add to that, someone should be, and someone was me since the beginning of the internet until we sold the dealerships in 2019. Every day I looked at least 4 or 5 websites to see if there were complaints and respond to them promptly. And after I posted a response, I'd pick up the phone and invite them into my office and fix the problem in my office. So that's number one. Number two is I always advocate that if you have a customer problem, you give them options. You say, we can do this or we can do this. And even if there are economic inequities there, let the customer, you'll be surprised sometimes what the customer will choose. So here's a good example, is you say, I'm either going to give you, to fix your problem, I'm either going to give you a $500 service credit, or I'm going to make a payment of $450, right? You choose, either one's okay with me. Well, all the dealers in the audience know that $500 service credit is really only $250 to the dealership, but it's more money to the customer. And depending on what their circumstances, they may take one, they may take the other. If it's over a certain dollar limit, and I'll tee this one up for Michael nicely, I would always advocate that if it's a lot of money, that you put it in writing and you have them sign a release that says, if I'm spending in my threshold is about $1,000. I mean, to completely arbitrary number. But if you're spending more than $1,000, you say to the customer, look, I'm going to put in writing to make sure you're comfortable what it is that we're going to do for you that we've agreed to. And part of that is going to be it's going to protect you and it's going to protect me too. And then you give them a very simple one-page release of which Michael can give. Sometimes it'll have confidentiality if you're spending a lot of money. Sometimes it won't. Sometimes you put in something that says if somebody asks, how your experience was at ABC Motors, that your response is, I'm satisfied with the outcome, and you put that specific language in there, excuse me, to make sure that whatever happens, you're not spending money and then they're going out and bad-mouthing you, right? Michael, what do you want to add to that?
Yeah, non-disparagement provisions are definitely helpful in there. The only thing you have to be careful of a little bit is there's some federal rules that relate to what you can and can't require customers to do on social media. So it's something where we would have you just have to be careful about the way you write that. I wouldn't. That's something I wouldn't necessarily want just someone at the dealership to draft up. You'd want a lawyer to do that. Absolutely, yeah, exactly. The only other caveat that I thought about as you were speaking about that is, we're talking about some of these what we call heat cases. It's customers that are just unsatisfied for some reason. If there's something different, because Jade, your question was, who do you have deal with this? Under certain bodies of law, there's someone specifically you have to have deal with something. So if it's a, you suspect a data breach, right? Under a safeguards rule, you have to have someone specified that's going to deal with that. If it's something where there's an identity theft issue, under your red flags rule, you're going to have someone specifically identified that's going to deal with that. So we're talking about just sort of these general customer issues where they're not happy about something. That's fine to do it the way that Tom and I are talking about. Just be careful of if it goes into certain areas, you may have other obligations that you got to comply with as well.
Wow. Like 10 minutes ago, I was going to say to educate consumers about all the forms in their favor. That alone, that sounds like an interesting thing. But I think what I really want to ask, and I think that, when you look at the headlines, is there something going on in the marketplace where consumers need to watch out? Or is there an overreach of accusations of deceptive practices where it's really not a big deal? Is there a trend?
From what I see, and look, I have a unique perspective of this because I see all the complaints that come in. I with so many clients all over the country, I see all different types of things, and I can tell you a lot of what I see is the dealer saying, I didn't know they did anything wrong. I was trying to help the customer and did this, and they took it wrong this way. So it was that issue. And I think they genuinely mean that. That's not just, lip service. That is a genuine, look, I don't think I did anything wrong. I was trying to be honest as I could with the customer. And they, later on, they just said, hey, there's this other issue. I'll give you an example. I had a client that had a customer that they gave a Carfax to, right? So, hey, a complimentary Carfax report, here you go. Sign off on it saying, look, it's Carfax. It's not me. I'm not making these claims, but Carfax says this, and here you go. And it said there was no accidents. Well, it turns out, a couple months later, Carfax updates and says there was a previous accident. And so the dealer gets sued saying, well, you lied to me. You told me that there was no accidents in this vehicle, and the dealer's going like, "What do you want from me? I didn't know. It's Carfax. It's not me. I'm not dealing with that. I would have no better idea about this than you would." So those are the kinds of things where you see it's like that will read in the headlines as car dealer sold faulty car. The car has been in an accident to innocent victim and blah blah blah. That's not really what happened. Now there's that end of it. And then there's the other end of it where you do see sometimes where there's some bad actors. Like, look, it's every industry there's gonna be some bad actors. So I think there are certain things that it's as much as there are laws and things to protect customers, it still should be to some extent a buyer beware kind of an attitude that someone takes into buying such a big purchase. That would be my advice to a consumer. Is look, I don't think there's a lot of people out there that are just trying to get over on you in the dealership world, but read the contract. if when they put something in front of you, read it. That's going to help you, give you go a long ways to making sure that you're protected.
So, Michael, isn't there also a standard that, using the example that you just gave, that the dealership either knew, or if they didn't know, they should have known that this vehicle was in an accident? Isn't that a legal standard that most plaintiff lawyers come after dealers with? They say, okay, so you didn't know, but you're the car professional. You should have been able to look under the car and see that it was in an accident. You should have known, and therefore I don't even care what the Carfax said, and I don't care whether you said it wasn't on there when they bought it, and I don't care if you have a signature from the customer on the Carfax. None of that matters because you should have known. Isn't that how it happens?
It's in a large part it is, and there's even this consumer protection statute in Florida has a provision that says you're not allowed to represent the condition of a vehicle unless you know or reasonably could know what that condition is. So it's not something you can say it's in great condition, but you really don't know whether it is or not. That you can't do. It's so the caveat. Yes, you're right about the know or reasonably should know. That's why a lot of dealers will say, look, you're buying this as is. I'm making no representations or warranties about the condition. This is the Carfax report. Take it for what you will. But that's not my representation. That's Carfax's representation. So yeah, now if there's something where there's some clear frame damage, there's some clear, the one door is missing, right? Okay, something happened. We know that, right? But beyond that, it starts to get to a gray area. It's like, well, how am I supposed to know that this was in an accident that had been repaired? It was a good repair job, so I didn't see it.
Yeah, but I just, Jay, when it comes to these things, I'm going to go back to what I said a little earlier. Fix the problem. You're not going to win in court. Fix the problem. I mean, there was a case in Virginia 20 years ago that a dealership sold a BMW. They represented that it hadn't been an accident. It turns out the whole car had been painted. The dealership said, we didn't know it was painted. So it went to court. The verdict was in the $150,000 to $200,000 range, and they had to pay their lawyers, right? And whether they turned that over to their insurance company and whether it was covered or not, I don't know. But you're going to spend time, energy, money. Your employees are going to get deposed, which is very upsetting to them. You're going to take the plow out of the field of selling cars and servicing cars when you have these distractions. And so I would advocate you fix the problems. There are ways to do it to minimize your outlay, but just like there was a case recently up in New Hampshire. A Chevrolet dealer sold a new Suburban to a customer with the check engine, a known problem about the check engine light, and the customer came to renew their inspection sticker, and they couldn't get an inspection sticker, so they couldn't drive their brand new Suburban. And it turned out they found out that the dealer knew about this problem prior to selling them the car. The customer goes back. The customer says, "Hey, you sold me this car with this problem," and the dealership said, "Sorry, there's nothing we can do." And this is in the newspaper. It's in the Boston Globe. And so my take on that is there's like 15 different things you can do. Number one, why didn't they trade him out of it? Number two, why didn't they keep the vehicle and give him a loan until they could fix it? Why didn't they call an engineer from General Motors to try to get down to figure out what the problem is? Why didn't they back out the deal? Like, I can go on and on and on with various things, but they just said, there's nothing we can do. And so last I looked, there was 333 comments on that article in the Boston Globe, right? So they're ruining their reputation. They did the wrong thing by the customer. Everybody knows it. There's no excuse for doing that. And they just want to be stalwart and say, we didn't do anything wrong. Fix the problem. I mean, just fix the problem. That's what needs to happen.
That's a heck of an example. I think so. Then, all right, we talk about litigious societies, one specific litigious society. We're just quick to not understand, and that gets litigious, and then we don't know that, yeah, most things settle. We should get in that bucket too.
Well, I'm going to let Michael take this one after I make a quick comment. here's how the dealer cycle goes. They get a lawsuit, they turn it over to their lawyer, and they say, handle this. Then the dealer gets the first bill and it's $35,000. And they call the lawyer and they say, are you nuts? Why am I getting a $30,000 bill? And the lawyer says, because you told me to handle it. And so I'm litigating. That's what you asked me to do. And then they use a bunch of expletives and they go, well, just settle it. And that's how it goes, because they allow their emotion to overcome good business judgment. I mean, after all, you're in business to make money. Mm-hmm. It doesn't matter. I said this earlier. It doesn't matter who's right, who's wrong. Fix the problem. Michael?
No, it's true. I mean, it is. It's look, the litigation is more than just costly. It's to Tom's point, it's the distraction that it creates, and the consternation that the dealers have to go through, and kind of reliving the issue over and over again, and then getting the attorney's bills, having them, a lot of these, depending on the type of complaint it is, if it's a lot of the consumer complaints, they have attorney's fees provisions that go along with them. So it's not just paying the dealer's attorney, it's paying being potentially on the hook for paying the other side, which makes it a little bit more complicated to settle at that point. Now, think about this. So to Tom's point, we're at the beginning, we could have resolved it for a loaner while I figure this out, or unwinding the deal, or doing something that is reasonable, that we can get things done. If we don't do that, and let's say we get 6 months into litigation, and everyone's got big attorney's fees now, if the settlement part of that is the plaintiff's attorney isn't getting paid, the plaintiff's attorney usually is working on contingency, so they only get paid once the plaintiff recovers something. So now to recover something, that means it's coming out of the dealer's pocket, and that makes settlement that much more difficult, because now we're not talking about the issue anymore. Now we're talking about the issue plus their attorney's fees. And with the dealer's perspective, all right, I'm already paying my attorney this much, so now I'm going to pay that attorney and settle these claims. It just makes it more and more difficult. The earlier you can resolve it, if there's going to be a chance to resolve it, the earlier you can do it is usually the most meaningful chance to do it. So sometimes, even if it's a minor issue that I think there's a chance that we can resolve it through a settlement, sometimes I encourage clients to go through early mediation as well. That can help bring the parties to the table. The mediator can push both sides to a little bit of a middle, something more reasonable, and help get that resolved. But the incentives definitely change once the case gets going. And I'll tell you another way that attorney's fees get involved is for dealers that have employment claims, for wage hour claims. Under the Fair Labor Standards Act, it's a one-way fee provision, meaning if the employee wins and says, hey, dealer, you didn't pay me correctly, and the judge goes, yeah, they didn't pay you correctly. Okay, now you got to pay me correctly. You got to give me liquidated damages for that, which is double whatever the amount was, and you have to pay the plaintiff's attorney's fees. Okay, it doesn't go the other way though. If the dealer says, hey, judge, I paid them exactly what they worked, there was nothing that I owed them, it was fine. Judge goes, yeah, you did. Okay, you can go home now. They don't pay your attorney's fees. So it's only a one-way fee provision. So I can tell you, most clients that get hit with an FLSA suit, particularly when it's a collective action, there's a little bit difference between a class action and a collective action. We won't get into it, but that's where it gets very, very difficult, because now you have a plaintiff that's going like, well, what's my incentive to drop this case? The more time they put into it, the more they're going to owe me. I'm not going to owe them anything. I'm not going to owe them attorney's fees. I don't have any skin in the game here. So I can keep going and going and going, and all it's going to do is rack up their potential liability. So a lot of dealers say, I feel very extorted when those types of claims come, and it's by virtue of that one-way fee provision.
And Michael, can you use offer of judgments in those cases? And
No.
we explain to everybody what that is?
Yeah, so a lot of times in civil cases, you can do it's called proposal for settlement or offer of judgment, and it's if I give an offer, it's a formal offer. It's not just like an informal, hey, I'll settle it for this. It's a formal offer that you serve on the other party. If they don't accept it, and it turns out that it was a reasonable offer, now they owe my attorney's fees from that point forward. And usually for a reasonable offer, it means it's within 25% of what the actual judgment end up being in the case. So it's one way to do a fee shifting provision. We're in the American rule here, meaning each party bears their own fees. That's one way. Fees can get shifted either by statute or by contract. but that's one procedural mechanism that you can shift fees. And in some cases that works. In a lot of cases where there's more public policy type issues involved, like wage hour claims, you can't do that.
That's interesting. What's that called?
Offer of judgment, or
Offer of judgment. Now, is that in any way similar to summary judgment?
No. So offer of judgment is basically it's a mechanism to either get the case resolved through a settlement or to shift the potential fees over to where if I'm not reasonably settling it, now I know I'm going to have to owe this party their attorney's fees. Summary judgment means you get to a point where generally after discovery, there are no factual issues that are in dispute related to the claim. Everyone agrees this is what happened. Everyone agrees the customer came into the store. Everyone agrees we sold them this vehicle. This is the contract. Everyone agrees that this person said this and this person said this. Now, the only thing we don't agree on is a legal issue. How does the law apply to those facts? If you only have a legal issue, sometimes you can resolve things through summary judgment, and then you don't have to go through trial, because the trial, remember, the jury is going to be the finder of fact, and then you'll have the judge is going to be the trier of the law. And if there's only legal issues, no factual issues, I don't need a jury. We can still let the judge decide it.
Very interesting.
Dealers can't win those very often, Jay.
There's almost always facts involved.
Right. Let's do this. I wanna hit upon this before I let you go, and that is that where is it at? CDK.
Mm-hmm.
CDK. $100 million settlement. Now, as I'm reading it, pay $100 million to settle a class action lawsuit. Okay, what's the lawsuit about? Colluding to overcharge dealers by charging high fees to access their own data.
Mm-hmm.
I'm reading this, I'm like, what? Does anybody want to weigh? Can you weigh in? Because this sounds crazy.
It is crazy. And a lot of states have now passed laws that say, regardless of your DMS provider, whatever your contract is, dealer's data is dealer's data. It belongs to the dealer. Up until that point, the CDK and Reynolds both were taking the position that, hey, look, you're housing it on my system. It's my data. I can let you have it. I cannot let you have it. I can, if you want to have a party that integrates with that and does that, they have to pay me a fee. There's a whole bunch of stuff that goes along with this. That's why I think there is the one case still pending in CDK, the auto loop case. But they settled. I think that was the last one to settle other than that one. I think Reynolds and CDK both settled. But a big part of the claim was that they were both sort of taking the same position, sort of colluding to be able to do that, so that, if I can't switch to, Reynolds from CDK because they're going to do the same thing. I can't switch from CDK from CDK to Reynolds because they're going to do the same thing. A few things have changed since that was going on. Like I said, the state law issue has been an issue. There's more DMS providers now. Techion's making a real dent in the market. They're getting a lot of market share now. So there are a lot of factors now that are playing into it that weren't playing into it before. But it was a real problem for dealers who, particularly when they were trying to either switch DMS providers or they had something that they needed to get to a vendor and the DMS provider wasn't allowing them to access the data that the vendor needed to do their job. It became a big issue. So that's why you see some of these the judgments and the settlements in large amounts.
Well, and it's 12 to 17,000 dealerships. And is this an old way of thinking, or did somebody 10 years ago go, yeah, this doesn't make sense, this can't be right?
Yeah, I mean, it was, no, I think for a long time it was something that dealers had complained about and said, like, it's not fair. It's actually pretty ludicrous for you to be able to say, I'm bringing in customers. Because remember, a lot of this is customer data. So I'm bringing in customers. I'm putting in the effort to gather their data. I'm subject to all of these, restrictions and safeguarding requirements for their data. Their privacy requirements for their data. I'm all these things I'm subject to, and I'm putting them on your system to be able to use it. And now you're telling me it's yours? That doesn't make any sense. And that was, so a lot of dealers were very upset about that.
We're taking photos, and then Verizon says, "You want to see it? It's a quarter."
Great way to put it. Absolutely.
What?
It's a great business model if you can do it, Jay.
Yeah.
Yeah, right on, man. Somebody's like, man, we should have done that.
Yeah.
Wow. Did we miss any headlines or lawsuits that we wanted to touch upon? I know we get in the weeds fast. And I also think that there's somebody in the live chat that's got to be thinking, live chat or on demand, thinking, well, can we talk about like carrier lawsuits? And I've got there's this guy named Brian Riker. Mm-hmm. He works in compliance in the carrier side in trucking. Mm-hmm. And we had a show for a while. And what we're talking about now is reminding me of that this is a periodic check-in we could be doing or something. I don't want to bite off more than I can chew, but I'm enjoying this show.
Yeah, no, and I'll tell you, there's a lot. Tom and I could go on forever, but just like you said before, I mean, there are things that we won't be able to get to. Like there's the Florida Attorney General said that, sent letters to dealers saying September 1, we're going to start enforcing laws that have been on the books for years, but we haven't enforced this way before. New York Attorney General has issued some statements about what not just dealers, but what businesses can do and for their privacy. You see like these pop-ups that say accept cookies. They found a lot of businesses that are doing that incorrectly under New York law. There's a lot of these actions that I think that are dealers should be aware of, and it really honestly business owners, carriers as well should be aware of, that are going on that we start seeing trends for. When COVID raised all the prices like crazy for used vehicles. One of the byproducts of that was the customers that were on leases from before that now had a payoff amount that was crazy low compared to what their fair market value for the car was. So everyone started, instead of just turning the vehicle in at the end of the lease, started exercising the purchase option. Well, that got people started to look at the Consumer Leasing Act and Reg M and said, well, wait a minute. Now there's that statute and that regulation says you can't charge anything except for what's in the contract, what's in the lease contract. But dealers were, just as a matter of course, saying, okay, but I might be arranging for financing for you to buy the vehicle. I might be doing other things. So I still have my dealer fee in there because I'm still doing documentation for you when you come in to purchase it. Been a million lawsuits about that issue because it doesn't say you can do that. There's still some gray area in that, but we see, you see these trends. And if you can get ahead of them and be able to say, hey guys, we got to start doing this. You got to start, pay attention to this because this may be an issue for you guys. And then really kind of get involved and really with what Tom does for getting in there in the nitty gritty of it and being able to say, here's the systems to make this compliant. That can be a huge help for not just dealers, but for carriers, for business owners in general.
That's right.
Well,
I mean, Joe, the most important thing I think in what the most important thing for any business is that you can't just say, well, I didn't know that, so I didn't do anything about it. Right? That doesn't fly with the FTC. It doesn't fly with the AGs. It doesn't fly with plaintiffs' attorneys, and you expose all your assets when you do that. And one of the questions I get very often is, okay, I don't have any compliance program. I don't really understand my insurance. I don't know what's covered and what's not. Where do I start? What do I do? And my answer for that is, number one, you should understand everything in your insurance policy. And if you don't know about your insurance policy, you get somebody like me, get somebody like Michael, get your insurance broker in your office and sit down with them with your policy, and you go over it so you find out where your soft underbelly is. So you find out where you're exposed. And you'll be shocked at where you're exposed and how much you're exposed. And so that's where I would start. Secondary to that, after you figured out how to cover all those holes, then you start by complying with one thing. And just like I was at a client today, we started a kind of a new software to help gather all the information like I talked about at the very beginning of the show. And I said to them, we do one of these a month. Because if you do more than one, you're going to get overwhelmed and you won't finish it and you won't be successful at it. So let's start with one. And once you got one, then that one may take 2 months. It may take 3 months. Depends on which issue you start with. You get that one, you make sure you're compliant, you put that in your basket, and then you take on another one, and then you take on another one. And every month you take on one item and you make sure that your business or your dealership is compliant. And over a period of time, you will be, quote, compliant, and you will be able to show your compliance efforts to a regulator or a judge and say, yep, you know what, we made a mistake on Mrs. McGillicuddy, and we're going to try to fix Mrs. McGillicuddy, but don't tell us we're willfully non-compliant. And by the way, the FTC fines are $51,744 per violation. And if you make the same mistake over and over, they're not clear whether that's 10 violations or 1 violation, and they want to leave it that way so they have leverage over you. You don't want to be having that conversation. And by the way, in most insurance policies, those fines are not covered. So that's coming out of your pocket. It's not something you can turn over to your carrier. So, you know, my advice to all the people who are listening is you start by starting.
Wow. I'm assuming, I mean, you've already, you know, I do media. Tom, you're in compliance. Michael, you're in legal. But I see there's an opportunity here. I don't know if you're already making programming or what it is. I also have an interest in this legal stuff just because it's fascinating.
Right.
So, talk amongst yourselves and think about coming back to this periodically with some idea, because this is fascinating. And one of the things I'm also thinking, and I hate saying this stuff out loud because I'm always assuming there's somebody thinking, yeah, that's it, I'm gonna take Jay's idea. Okay, is that if we had let's say we had a quarterly show or a every other month, and we had a predetermined, we do it live, and we have a predetermined time, and we develop a bit of a structure and news items as well as the sales side, Tom, like you were saying, right? Because there's a lot of potential clients out there. You're building awareness of this conversation and the expertise without providing exact legal advice, but getting a conversation going. I don't know. I think that's pretty fascinating. I think there's something there. So think about that.
Yeah, I'd love to.
Michael and I are available.
That's it.
Right. Me too. Yeah, man. Where's that applause button? We were talking so long. You know, I got this whole studio here, right? And I found some great nuggets. I look forward to, I'll try to make a couple video shorts out of what we did here tonight. And I really believe in that idea. Me and Brian, okay, so we had a show, DOT compliance. Mm-hmm. And we were trying to do it every week. That was way too often. But there were times where in the trucking and carrier side, we were talking to individuals that were facing either a fine, a violation, a question, a concern, a licensing issue, overweight, regulation, and you come to find that there are all these, and then we started to identify these patterns, right? These are definite patterns, and so anyways, that came to mind as well. Will Morris has a question. Is Mr. Kline doing auction compliance work? Asks Will Morris.
I would say, excuse me, in part, it depends on the specific nature of the questions. But I'm happy to talk to Will, just have him reach out to me through social media, LinkedIn, or I can give my phone number, and I'm happy to get the call.
So I'm so glad we're at this part. How does somebody contact you? Tom, you go first.
So my website is bettervantagepoint.com. I'm on LinkedIn. I'm on YouTube. I've got a YouTube channel with 150 videos of talking about these topics. You can reach me by my email, which is Tom K, as in Tom Kline, Tom K at bettervantagepoint.com, or my phone number is 757-434-7656. Michael?
Yeah,
Awesome.
Yeah, for me, it's pretty straightforward. It's Michael Semanie. I'm on LinkedIn. Semanie Law is the name of the firm. The email address for me is msemanie at semanielaw.com. And go there, and I'm certainly happy to chat with anybody about anything. I think Tom and I both have sort of the passion for being able to make sure businesses, dealers, everyone in the auto industry is doing things to protect themselves. Dealers invest a lot of money in these businesses, and so for me, it's things like, how do we make sure that when you do exit, that you're getting the most that you can. So making sure that your privacy notice is going to give the buyer the right to be able to contact their customers. Otherwise, they're going to start lowering the price when you get to the closing table because your privacy notice isn't correct. Those sorts of things where it's not just how do you stay out of trouble, but how do you maximize the value of your investment as well.
Agreed.
Appreciate that. Awesome. So I got some information in live chat. Will, thanks for that. Appreciate it. Any final thoughts?
Go ahead, Michael. You start.
Yeah, for me, it's I think it's kind of what Tom's touched on at the beginning, is that compliance is kind of become a dirty word, just because people don't want to do it. My perspective is a little bit different. My perspective is, let's keep you focused on business. We want dealers and businesses to be able to focus on what they do best. Selling vehicles, servicing vehicles, doing what their business entails, and how do we insulate them from these distractions like the lawsuits and like the other things that could not just cost them money potentially in having to resolve, but also cost them the time and distraction of having to deal with. And again, making sure that they're the longer of a track record you have of being in compliance, now someone comes in that wants to buy your dealerships and you want to exit, you're going to maximize the value of that exit as well. So to me, that's the important part of compliance. It's not doing what the government says for the sake of doing it. It's in your own self-interest to make that happen.
Well, and there's a lot of M&A happening now.
Absolutely.
In auctions, in dealers. Probably, is it always that way? We just don't fully notice? What's going on?
It's been a very, very hot market. I'm actually going to Vancouver in a couple weeks to speak to Canadian dealers who want to invest in U.S. dealerships because it is such a hot market. It's an event that's being put on by Dealer Solutions, Mergers and Acquisitions, great M&A company advisors. BMO Harris is going to be there. Witham is going to be there. So the M&A activity has just been really kind of off the charts for a while now. It's slowing a little bit, but I think it's slowing to become to more of a sustainable pace. It's not slowing like it's getting that anyone is losing interest in anything. It's just now becoming more of coming back down to earth just a little bit.
Tom.
Yep. So listen, compliance and risk is not sexy. Newsflash, it's not sexy, right? Everyone would rather try to sell a car, work on advertising, work on marketing, work on all the kind of the quote fun side of the business. But what I would say to the dealers out there is, this is just something you have to do. And you've got to start by starting. And so if you haven't done anything, spend 15 minutes when you get to your desk every day, just 15 minutes, and you'll be surprised at how much progress you can make. Not saying you have to hire somebody full time, not saying that everybody, that you need to stop the dealership and stop selling cars to work on this stuff, but you gotta do a little bit each day, or you'll always fall behind. And so that's number one. And then number two, absolutely, no matter what you do, talk to your insurance professional and understand where you're exposed. If you don't know where you're exposed, just to tie it back to some of those consumer complaints, let's say you only have $25,000 of consumer complaint coverage and you get sued for something that's not in your insurance policy. You're self-insuring all the rest of that. There are so many examples. I mean, we could have hours of conversation about which insurance policies you should look at and what limits you should talk about. And that could be its own series for the rest of the year. But I would just encourage to protect yourself, start by starting.
And I was going to ask you where you start, and is that where you start, with insurance?
I would start with insurance. And the reason I would start with insurance is the on the risk and compliance side, you're trying to protect the assets of the dealership. That's the whole point of it. And if you want to make sure you're protecting yourself against a catastrophic problem that may put you out of business. And don't think that it doesn't happen, because it does happen. I see it. Michael sees it. It's preventable. It's just up to the dealer or his designee to work on these things. And like I said, this is not sexy stuff, but it's very important to work on these things in order to make sure you're safeguarding yourself.
Have a cup of coffee with your insurance agent
Every day for a month, and then you'll
It's a great idea. Every day, yeah, and lunch every day for a month.
And once you do that,
Jimmy John's.
absolutely, gotta be Jimmy John's.
Wow. That okay, so that actually, what I like is there's the takeaway. For anybody who made it through this legal marathon, your takeaway is talk to your insurance agent. You will learn stuff, won't you?
100%.
Yeah. Because you can't call your lawyer. I mean, that's not something, right? I also like to, I always think of like the dream team. You have a dream team. I didn't think of it this way when I was younger, but somehow along the way as I got older, you have your dentist, your doctor, your lawyer, your accountant. You have a therapist, right? You have your dream team. And they're not easily accessible, this dream team, but you need them.
Right?
You don't need them every day, hopefully, or every week, or even every month. But when you need them, man, do you need to summon that member of your dream team.
That's right.
That's right. And what you need to do is be able to walk around with enough information to know when you may need to summon that person.
Sure.
And then how to expedite that conversation.
That's right.
Just like you tell your doctor exactly what's going on. You don't beat around the bush.
Right.
I got a pain. I don't know where. You don't do that. So,
and alternatively, Jay, if they don't want to do that, then buy my book.
Does this hurt? Right?
Wherever books are sold.
Okay, so let's talk about your book for a second. Yeah. So, Tom, what's in your book? You sent me some. I got the book jacket. What's in the book? Tell us.
Yeah, it's a primer on risk and compliance for dealerships, right? It talks about where to start. It talks about what insurance you need to be concerned about. A lot of the topics that we've touched on here, there's 53 chapters. I tried to make it interesting. One of my colleagues did a review on LinkedIn yesterday and said there's some pretty hilarious stuff considering this is really boring shit. Right? that was his review, and I appreciate that. Right?
Because that's a good review.
I tried to make it entertaining and make sure that it's a good read. It's an easy read. It's broken into 53 chapters, and each chapter stands on its own. So it's not like you have to read all 53 chapters. You can read a chapter and think about it, maybe act on it, do something in the dealership relating to those topics that are discussed. And that's how it's designed. It's designed as a primer for a dealer to say, where do I start? How do I do this? And so I think I hope that you'll find that the book does that, and that was the goal for it.
Maybe then, because then the insurance agent is in the dream team, and maybe then what could happen with such idea is that maybe there's a way to weave in a takeaway from your book of ideas and suggestions within real life examples. So
we can talk about that maybe at our next show. We'll start with the insurance.
Right. Well, gosh, it's always hard to say goodbye to a great conversation. But thank you.
Absolutely. No,
for
thank
all
you.
your personal time. This was a lot of time. So, to me, the live audience, and those on demand, Tom Kline, Michael Semanie.
Yep.
Semanie. All right. Gentlemen, thank you so much. I really appreciate it. Keep in touch. All right, have a good night. I'm going to end the meeting and cut. Okay. All right, there we go. So, now it's just us. It's just me and you. Dealership Lawsuits 101. It's when I put this show together, I talked to Tom. I thought of Tom first, and I said, listen, Tom, I want to put together a show. I'm seeing dealership lawsuits in the headlines. I also found it interesting because, car dealership guy, he was talking about dealership lawsuits like either today or yesterday. CBT News, Automotive News. There's something going on with dealership lawsuits at the moment. And I thought, well, put this show together. We just put it together last week. And he recommended Michael. And I thought, well, it sounds like a series or something. So I think that there's more to do here, and it's not sexy, and there's not a ton of people. What I wonder is if you get maybe there's a dealer in a legal situation and gets the podcast and listens to it, rather than another true crime episode, listens to Dealership Lawsuits 101. I don't know. I want to thank everybody. Thank you, Superflow Systems. Thank you, ClearPath TMS. Thank you, Tom Kline, Better Vantage Point. Thank you, Michael Semanie, Semanie Law Firm. Thank you in the live chat. Thank you so much. And for those on demand, thank you for watching and listening. If there's something I can help you with, send me an email, autotransportintel@gmail.com. Visit ATI Auto Business. Oh, look, Tom is calling me now. Well, Tom, I'll tell you what. Listen, man, I'll call you back, but I got to wrap up the show. I want to thank everybody so much. And, please do join us Thursday. Self-dispatch load boards. Yeah, like you're a carrier and you're still listening. But if you are, you're probably more keen to legal pitfalls than the average car hauler. Maybe, maybe not. Or you just, are waiting to... you're still waiting on your shower at the truck stop. It's possible. Anything's possible. All right. Well, thank you so much. I'm going to end the show. I got to get Tom's call, and we'll be in touch. Car hauler now. And cut.